the first to know Nsem-Pii TV.
Finally, Ecowas court akasa and ruling no about via Zoom. Now na the Attorney General representing the government of Ghana and I feel lawyers Femi Falana and Falana Chambers what Nigeria Abuja representing her ladyship Justice Torkonoo now ejina ATB. Asam de Edema her ladyship Justice Torkonoo asam de yipa. Ni nyina say Ecowas court chiremua they have established a prima facie case. Say her ladyship Justice Torkonoo the suspension and the removal process violate her rights under the African Charter on Human and People's Rights. Now, harmful to her reputation. Now, case in 3 different parts. Menya brenda ma church 3 parts ni munyina. The first part, her ladyship Justice Torkonoo filed for violation of her human rights. Now, violation of a human right, na a family But I say, you violated the right to fair hearing, defense, and an impartial tribunal. Article 7 of the African Charter on Human Rights and Harmful Reputation. And 2, violation of the right to dignity and protection from arbitrary measures. And 3, violative of Article 4G and 4J of the Ecowas Democracy and Good Governance Protocol. A guarantee judicial independence and security of the tenure of judicial officers through chief justices. And a 4 say Ecowas court enfotabo into a juma the committee of inquiry no so inti sanity ruling on Ecowas court di aba bonten ne no Ecowas court aje the atumu say in fact over establish a prima facie case of violation of human rights to fair hearing in Ghana's constitution and Ecowas protocols. Until all the 3 human rights violations, her ladyship Justice Torkonoo and the Ecowas court no. Ecowas court on penny for trans and almost say no crack. Omo which they say there is a prima facie case that has been established, say no crack. In hearing the case leading to the suspension and the removal of her ladyship Justice Torkonoo as Chief Justice of this country, there was a violation of human rights to fair hearing. According to Ghana, your constitution, and according to Ecowas and so protocols. The Ecowas Community Court therefore ruled in a lucid voice that the Ecowas Court too has a jurisdiction to hear the case. The Office of the Attorney General representing the government of Ghana and so filed a counter motion say Ecowas court any to me say one obetra say ebua say Mahama her ladyship Justice Torkonoo in the government of Ghana's quest to suspend her and to remove her na ne rights violated. Ghana by through the Attorney General file Ecowas court to say Ecowas court any sa to me say obetra say case no so ti de to mienu. Apart from say Ecowas court, I established a prima facie case. Say ampa Mahama you violating the rights during the whole process. Ecowas court assign ruling bio say someone Attorney General beka so omuni jurisdiction. Oma body atuogu. Almost say they have the jurisdiction to hear the case. That is ruling number 2. Ruling number 3. Ecowas court Abo Justice Torkonoo and someone now watch say committee of inquiry asetna omo try na ɛyɛ unconstitutional. The Ecowas court about to say the committee of inquiry sitting na ɛyɛ constitutional. It almost sitting in the constitutional. But within their sitting there, a prima facie case has been established. Say, my main fundamental human rights were violated. Into one, a prima facie case has been established that a leadership Justice Torkonoo, a right, fundamental human right, they were trampled upon. 2, Ecowas Counsel ruling say, government of Ghana said on catch on say omuni to me so better transfer me so on so mo botugui almost omo to me such the substantive case on better transfer. 3, obo Justice Torkonoo and so application file yes committee of inquiry about and na constitution the Ecowas court about to say committee no na committee no constitutional. The formation of the committee was within the constitutional right of the government of Ghana. But a juma mo ya there. Prima facie case has been established. Say there was a violation of human rights. Yantuaso, the Republic of Ghana during the delivery of the ruling of the court ordered the Republic of Ghana to file a defense. No, the Ecowas court during the delivery of the ruling of the court has ordered the Republic of Ghana to file a defense to the case that has been established. That is a prima facie case of violation of human rights to fair hearing within 30 days. And the Ecowas court assign Ashe Ghana by say within 30 days a day enemy omo file omo defense. No mo chiremu say omo antietia ye maame get to Torkonoo for ahodie so because omo as a court there omo to me establish a prima facie case say nyoma ekọ so prior to the suspension of maame no nyoma ekọ so prior to the removal of maame ni nyina no a constitute violation of human rights. It Ghana by filing the defense no for me kire say and then no correct so omo violating maame no right during her removal, during her suspension. Ghana, through the Attorney General, is yet to officially respond to the weighty claims of the applicant, Chief Justice, since the filing of a case some 4 months ago on the 4th day of July 2025. The Ecowas Court, Community Court, per its ruling, said it could not grant provisional measures to stop the removal of CJ Torkonoo because Ghana has already gone ahead to remove Chief Justice from office and sworn in a new Chief Justice. And another statement made by the Ecowas Court, they say, Obu to be granted provisional measures to stop the removal of the Chief Justice because Ghana can't to sign a money we in the ama ya swear in a new Chief Justice. And Tisana Montono Swa, and as I relief Funua, now her leadership Justice get to Torkonoo is seeking from the court no and some grantia in a year. The application for provisional measures was filed on 4th of July 2025, 3 months after the suspension warrant, negating the agency requirement for provisional measures. The application for provisional measures, which is cast in the mode of interim or interlocutory orders pending the final determination of the case, can be read from the Ecowas Community Court. In the face of the orders of the court for the filing of a defense, the Republic of Ghana sought to have Justice Torkonoo's application for default judgment withdrawn. But Justice Torkonoo's lawyers prayed for the application to stand, as the Republic of Ghana could still fail to file a defense despite the orders of the court. It way Nsem-Pii APMU breaking news is here from the Ecowas court. The court also addressed a separate objection by Ghana's Attorney General, who argued that the matter was subjudice because related issues were before a Ghanaian court. The Ecowas court disagreed, describing the objection as misplaced. According to the ruling, the application before the regional court concerns alleged violations of Justice Torkonoo's human rights during the suspension and removal process and does not seek to review or overturn any decision of a Ghanaian court. The judge further clarified that the subjudice principle applies only when a matter is awaiting judgment elsewhere, not merely because two cases share similar facts. The court concluded that it has jurisdiction to determine the substantive matter, having established an existing prima facie human rights claim in the claims made by Chief Justice Torkonoo. It therefore declared the main application admissible and has directed the Attorney General of the Government of Ghana to immediately file a response. And the Attorney General argued, said, Asemi, if you Supreme Court ayenkaye, if you High Court ayenkaye, and he said, Ecowas Court Sekan, na akwakwa bibia almost some friend subjudice, and Ecowas Court Chilima. There was Supreme Court, there was High Court, no, and yet human rights assembly. There, Yamami Justice get to Torkonoo Jabeda Woman, a border on human rights. Yet, the fan who deals during her removal and her suspension process. And yes, our case no there was Supreme Court, and yes, our case no there was High Court. It will be to me a translate. To Amaka Attorney General said, Omo trans we munampa. Mami fan who did her suspension to her removal. Yet, Tiasun to establish a prima facie case. And the Attorney General, unto me country say, Assembly of Subjudice, Debbie. The Ecowas Court Chilima. And the Manimu Yano, Ghana's Attorney General, and finally, the defense response. Interesting times ahead. Very, very interesting times ahead. Because now it can be established, say, the Ecowas Court Ajatumu said, Mamino human rights were violated during her suspension and removal. Ecowas Court Ajatumu said, the work of the Committee of Inquiry there is constitutional. And to almost stop or mujume diana so mu cancel mujume diano enye ye. Ecowas Court asaja to say, Yamami get to Torkonoo or delay in filing that motion seeking to quash a removal or delay to the government of Ghana a year free hoy or mutuminya hohe. Government of Ghana has swear in a new Chief Justice or mutuminya hohe. But the substantive case of human rights violation in the prima facie case has been established. Tiere the response Attorney General ebe filing with the Ecowas Court. And it is a refreshing news for embattled Justice Gertrude Araba Esaba Saki Torkonoo. Yedi the case yechi. Immediately the Attorney General ebe filing the defense statement. Yedi be bremo. Right from the Ecowas Court.
Good evening, sir. Can you hear me?
Yeah, I can hear you now.
Great. These charges that we have seen publicized, your client is not in the jurisdiction, but are you formally aware of the charges that have been brought against him by the OSP?
Well, good evening to your esteemed listeners and viewers. Yes, it's all over social media, so I have seen it.
And I mean, that's so informal. I'm talking about whether formally there's anything that has happened in the court at the registry. That's what I mean.
What has happened in the court in the registry?
Whether this has been filed formally in the court and served on your client?
I wouldn't know. That should be a question for the OSP to answer. I have seen the charges. I think about 78 of them.
What do you make of them?
What do I make of the charges?
Yes, please.
Oh, the special prosecutor, I believe, knows what he's doing. So he has now formally charged my client and others with whatever. Of course, I've spent time with Adnam. The duty of any prosecutorial team is to prove the guilt of an accused person beyond all reasonable doubt. So, yes, it's one thing formulating charges, and it's another proving the offense. So, for me, it means nothing.
But
he's charged, yes, fine. So,
okay,
he will have to prove the charges.
Great.
It's not the scribbling. It's just not the scribbling of English language on paper, which amounts to prosecution. There should be a conviction, and that conviction is based on proving the guilt of the accused person. So charges mean nothing.
Before we get there, the prosecution would have to make its case. You would have to open your defense, and at the end of the day, the judge would decide where to swing to. But has your client formally seen these charges, at least being brought to his attention by the court registry?
I am telling you that I have just seen it on social media. Indeed, if these charges have been formally relayed to my client, yeah, he would have told me. I am telling you, I have no such knowledge. I only have also seen it on social media, as you have. So I don't know yet whether he's been served or he's been formally notified of the charges. I don't know that for a fact. So I can't tell you that I know. I don't.
All right. Now, but would you represent your client in court when the charges are formally read and the case opens from the prosecution side, or you have indication that your client would come and take his plea or respond to the question of whether he's guilty or not in court?
Mr. This is a question to ask with all due respect. You've called me as well for kind of reactor. So indeed, if the charges are arraigned and the matter goes to court, I'll definitely be in court.
Okay. Will your client be in court?
But I wouldn't know for now.
Are there plans to get your client to come into the jurisdiction to respond to these charges?
I wouldn't know for now. He has not been formally notified of any charges. So the question is a bit preemptive. I can only wait for him to instruct me on what has been served or not served on him. For now, I have seen it on social media. I might believe that he also might have cited something like that. I don't know for a fact anyway, but I have seen it. I might believe that since it's all over the place, somebody might just prompt him that something like this has happened. So yes, I mean, I'm waiting for him to instruct formally.
Should that somebody prompting him not be his lawyer?
Oh, but why should I be the one to prompt him?
Because you are the one to defend him, so you have to bring his attention to the fact that the Republic of Ghana has brought charges against him, and Ken
Okurata is a widely read person. He's widely read, so I believe that he will do what is necessary by him.
Which includes coming to respond in court, having his day in court.
By all means, an accused person will have his day in court. So when he gets to that bridge, he surely will cross it.
Even if the accused person is not in the jurisdiction.
Why are you running over yourself? Why are you being so judgmental and prejudicial? What do you mean by even the accused person is not in the country? But once upon a time, all of you were here when the special prosecutor said that he was going to force his entry into the country. So why are you making this comment? As if Ken Okurata is fleeing justice? Don't do that.
Yeah, but I was
what do you mean by because he's out of the country?
But I was also here when he said he was going to come, but he hasn't. So that's why I'm just asking.
Yeah, because he has attended onto a medical procedure. Why do you only hear one side? He has had a medical procedure which is known to everybody. He is recuperating. When his doctors tell him to come to the country, he will come. What is this fixation about people saying they can this, can that? What's all this fixation about?
Because people are...
the man has gone for a medical surgery.
Because the OSP has said he's a fugitive of justice, and so people are interested in knowing whether he will come.
Are you going to the past? I thought we were going to the present and the future. Stop this past thing. The OSP says he's a fugitive from what justice.
But
you haven't charged anyone with an offense, and you tell me he's a fugitive from justice. Do you people say this thing just because you have heard it? You should understand what you are saying to me. What do you mean by the OSC says he's a fugitive from justice? And so, because the OSC says you are also repeating it ad nauseum, don't do that.
Mr. Davis, I'm just trying to get information from you. It is.
Yes,
I have no interest whatsoever in this.
But I'm saying that the information you want to get from me should be based on stated facts.
Yes, and the stated facts are that the Office of Special Prosecutor has said that your client is a fugitive of justice. He's making attempts to bring him home to face trial. However, he has gone to court and brought these formal charges. And I'm asking what your client is going to do. Would he come formally or he will be tried in absentia? That's what I wanted to know. You are his lawyer and better placed to respond to these questions, I believe.
I am saying, listen to me, I am saying that for now, I don't even know whether he's been notified of the charges. It is running over social media, and I'm saying he's a widely read person. He might chance on it, or somebody might bring his attention. But he has to be formally notified of the charges before we can be asking these questions whether he's going to come into the country or not. It's like, why? He has to be notified. And if that is not done, I don't think I'm placed to be answering questions on whether he's going to come or he won't come. I think I'm a clairvoyant. If he is formally notified, then we can be having the discussion whether he's coming or not. And indeed, when he's notified, you know. Because the OSP has a pension of doing everything he wants to do on social media, facing the microphone and cameras, but not in the courtroom. So when he notifies him, he will tell you people, and then you can ask me the questions, and I will answer.
Okay.
I said it the last time, and I'm repeating it. Kenneth Nanaya Kuntun Kunuku Ofoyata is so scared of prosecution. He is not in the least scared. So nobody should have any whimper that, Ken is running away.
Very well. We'll wait to see if he comes, and then
yeah. So wait to see that day. When he comes, not if.
Okay, when he comes. But in between now and then, if there's need for you to go and respond in court, you will do that for him while you wait for him to come.
Of course. Those are my instructions as a trained lawyer.
I'm just wondering though, so just for education purpose, usually they would ask guilty or not. Who is going to respond to that when it's made in court, so that you, the lawyer, definitely cannot be the one to respond to? So when it gets to that, what happens?
When that bridge also crosses our path, we'll cross it.
Thank you for speaking to us, sir.
Thank you very much, sir.
That's Frank Davis, his lawyer for Ken Oforiatta. This is Eyewitness News on 97.3 City.